was an amazing time.
Are you certain?
Hi, guys. Good little throwback there. So we are going to be looking at some Fulton County shenanigans. We might just have a What in the Fulton series starting off. Who knows? This is going to be the case of Georgia State v. Kenneth Poole. This is a retrial. So we're in the retrial stage. First trial ended in a mistrial. And the issue we're going to be looking at here, we're just going to speed through this. The state provided notice on Friday, November 21st, 2025 at 6:52 p.m. by email that it intends to call Dr. Matthew Broggie, hereinafter Juror 29, juror from first trial, an orthopedic surgeon who previously served as a juror in defendant's first trial, which resulted in a hung jury. An ER nurse who also served on the jury has independently previously stated that Juror 29 advocated strongly for conviction during deliberations. The state, this is Fulton County, now seeks to rebrand this former juror as an expert witness on matters relating to the same evidence he previously evaluated during deliberations. So, first impression thoughts, Jim?
Why? Why? There's like... how many? Okay, like I know they can't get like an orthopedic surgeon like on every street corner, but there's got to be more than one in Georgia.
Yeah, hopefully.
Just get another one. Like I know you're up to something. You're clearly up to something. I don't know exactly what. I have a guess, but like, why? That's my.
So yeah. For me, it's just. What in the Fulton? What in the Fulton? So we strategically have Aaron's tomatoes pinned up here as the comment. Thought it was very appropriate for the context we're going to be going through. This was recommended by Factual Lie. Factual Lie hangs out in Judge McBurney's live trial streams. He broadcasts his proceedings. So we're going to be rewatching what took place, this argument about this juror expert orthopedic surgeon as it took place on December 1st. So shout out to Factual Lie in the chat. Get some captions up. Defense attorney is over here. We're going to hear, I think his disbelief more than his argument necessarily. And we'll see how this plays out.
Really, like his face is how I feel on the inside. Like, that's how I feel too.
Oh, man.
And anything that I've ever said bad about any of the two people on the left, I meant.
Oh, hey, is that the investigator that Quindarius Zachary tried to talk to?
Yes, it is. I didn't. As soon as you said, "Is that the investigator?" I knew what you were going to say.
I almost forgot Quindarius Zachary's name. I just was almost about to throw in another Quay or Qua. Oh, yeah, man.
I mean, the state forgot his name too because I don't know how to spell it. But
yeah.
I actually don't know how to spell it either. There's a couple R's in there.
Yeah, I think it's 2 R's, and I spelled it wrong for like the first 5 days that he was relevant in the YSL trial. Let's get our haze over. So if you're watching over on my channel, you know I'm Katt Not Williams. We have Happily Angry Lawyer below me. Goes by Jim for short, or Hal. You can acronym his name. Make sure you're following his channel as well. It's linked in the description. We are simulcasting, so you can watch on either one of our YouTube channels. You can chat in both. You can chat in both chats. It's a great time. I see James is defying all odds. He's watching over on X, the old Twitter, formerly known as Twitter. So good to see you, James. Tatum's in the building. Candace is in the building. Zaya Danielle, good to see you. We've got Gigi, the first and best Gigi. Of course, Factual Lie, the reason we have this great recommendation to watch. So much appreciation. Tatum says, hey, also, is this even legal?
You know what's okay? I just noticed. Speaking of things that should be illegal, why are there so many little like file folder things on the defense lawyer's desk? Like, do you need so many?
Oh, over here, these things?
Yeah.
It's to show how much of a defense they don't have compared to the.
You're out of the prosecution's cases right here.
Because they have the cart. They should win. We have the cart. Oh my goodness. Yeah, there's some use for props there. And then we've got We've got C. Mish linking in. So there you go. C. Mish is taking use of the simulcast. Same thing with Samantha. There we go. I love this duo. We are officially a hybrid chat, guys. Officially a hybrid chat. We got tomatoes from Aaron in both chats. They're red. Be careful. They're red and green. So hybrid good times all around. Candace says he found the files that love lost. Oh man. Oh man.
You ever imagine if like there's a defense lawyer just like walking down the hallway and some prosecutor just comes up and just slaps it right out of their hand? Like, oh man, it's a shame that hack happened.
Oh yeah. just forget the papers flying all over the hallway. Everything's blamed on, what was that, like a 2019 hack?
Yeah, something like that.
It was a long time ago at this point. Oh man. James says legality is more of a vibe than a knowable thing nowadays. Very vibey. True. All right, guys, let's hit this play button. Let's see how the defense tackles. Let's see how far we make it before like losing our minds.
Name Dr. Brogy or Broggy? Brogy, Dr. Brogy. Mr. Miller has filed a motion seeking to exclude Dr. Brogy, and we can start talking about that in the time we have before the jurors get here. I don't think that's anything that will come up today anyway, other than that I would say his name as a potential witness, but I don't think that generates any of the harm that Mr. Miller was concerned about in his motion. So, Mr. Miller, I will start with you. If you want to tell me if there's anything you want. I read your motion. I understand your concerns, but if you want to get them more on the record today, you are free to do so.
First of all, how dare you?
Like that's the first word he says. Your Honor, and then the Cardi B.
Sure, Your Honor. The bench objects to the rebuttal witness that the state filed late Friday afternoon, and Dr. Matthew Brogy.
So let's get clear about the dates. I'm assuming it wasn't Friday the 28th of November.
That would have been Friday the 21st of November, just prior to the Thanksgiving holiday, as well as the Black Friday holiday that follows afterwards. And so he's a former deliberating juror from the prior trial. Same defendant. His proposed testimony is, we believe, is inadmissible as a matter of law and as well as constitutional fairness. First of all, under OCGA 246606B, juror deliberations or privileged testimony is inherently intertwined with the prior deliberations. Our testimony or our findings that it would be nearly impossible for Dr. Brogy to exclude what he has already seen and experienced as a former juror in the last trial, and as such should be excluded for that.
Let me explore that part with you. Dr. Brogy could have sat in court and watched the entire trial. I'm separating out the deliberation piece because I think that's the nugget we need to work through. But in terms of watching the trial, witness testimony, video evidence, your client's testimony, et cetera, Dr. Brogy or anyone else could have sat in trial and watched it, or it's live stream, they watch that. Nothing improper about that, consuming a public proceeding. Does watching the trial mean you couldn't then be a witness in a retrial?
That part would be, I would say, watching it, no. But being that you would have insight as to what the jurors are thinking and what the jurors are deliberating in the room and what nuggets that the jurors are looking for and were unable to get, that is the part where his testimony would put him as basically a super expert in a position that no other expert would be able to be in, because he has that insight.
What would be different from the state hiring a medical professional and that medical professional reaching out? The identity of the jurors from the first trial are known to the state. And so they hire an expert, John Doe, and a medical expert. And John Doe's kind of curious, having looked at the information, well, why wouldn't jurors have found it incredible to believe that someone could go from the back seat to the front seat in the car? That's his perspective. I think the way the car works and the body works, it's physically not possible for someone to have gotten from the back to the front and not sustained certain injuries that your client did not sustain. I'm curious about that. I'm going to go talk with the jurors, and the jurors agree to talk to him. Could he then not testify? He couldn't testify. Hey, I talked with the jurors and they told me, well, I didn't believe the state trooper, or Mr. Miller gave a persuasive closing argument. That would be hearsay and whatnot. But would the medical professional, is there something that prohibits him from interviewing jurors to say, well, tell me what you struggled with?
I think,
And using that knowledge to then tailor his presentation to the next jury.
I would say yes, because at that point, that individual is not basing their opinion, nor they're not basing their opinion on the science, which is what this expert should be basing it on. Instead, they're tailoring it towards the opinions of the jurors that were already inside deliberating.
Well, jurors from the previous trial, we'll have 12 new. I can promise you one thing. We won't have any jurors from the previous trial as jurors here. We may have one as a witness, but we won't have any as jurors. So it's a clean slate. It's different people. But this expert, in my hypothetical, because I'm wrestling with this as well. I'm trying to figure out the contours of the issues. And the example I came up with is this: they hire an expert who wasn't a juror, but is just puzzled. How could the jurors have come up with this way? Can I go talk to them? And they said, sure, if they're willing to talk to you, you can't coerce them. He calls them. Yeah, sure, I'll talk to you. Here was my concern, or here's what I thought. There's that space between the seats. And if you hit the wall at an angle, because it was the right front fender that really got crushed, you just slide right through and then you'd be in the front. And so this expert is learning how lay people thought about a situation about which there was precious little testimony. Neither side presented much in terms of an expert saying, here's how a body could or couldn't move from the back seat to the front seat. There was focus on oil in the eyes, what you could recall, the trooper's credibility, et cetera, et cetera. But I couldn't think of why you would be able to disqualify an expert who shared that part of the work he did was talk with the jurors from the first trial.
Well, he wouldn't be able to share that in the new trial. And if his basis of his opinion is off of whatever those jurors discussed with him instead of the scientific methods and whatever it is that his expertise is in, then he wouldn't even be qualified as an expert at that.
Well, two different things. One, I agree with you. He couldn't say, and I talked with jurors and they told me X. But I hope that's not what the state's trying to do, is to have him talk about the deliberations.
Look at Rao's face. Let's run that back.
Well, two different things. One, I agree with you. He couldn't say, and I talked with jurors and they told me X. But I hope that's not what the state's trying to do, is to have him talk about the deliberations. I suspect not. But the second, you have assumed, I don't know what Dr. Bogey's going to say, but you've assumed that he's going to abandon science and focus on whatever jurors may have been talking about. And I didn't get that from the notice. And I agree with you. If you were able to establish, and it may be something we do outside the presence of the jury, that, well, I'm basing my opinion that X, there's no way a body could have moved from the back seat to the front seat based on.
Every time they say a body, I'm thinking of Adam.
yeah, I think like the issue is that it's just hard to cross-examine, right? Like, you can't get into his bias. I mean, we talked about this for a second earlier, but I don't know how you get into his bias without getting into the fact that he was a juror in the previous trial.
Well, then if you can't cross-examine him, like the difference between the expert being in the deliberation room where everyone's having a discussion and hopefully like purposely entertaining different perspectives, playing devil's advocate, very different than when that same individual that you guys were saying in the chat couldn't sway the jury the first time. Yeah. Now you're on the stand and the defense would be constrained in cross-examining. So there isn't a full opportunity to flesh out and confront and challenge this individual who suddenly needs to be the orthopedic surgeon that's called as an expert witness.
Yeah. Also, it's just weird. Why are you going to be so weird every time? Just be normal. Just be normal once.
And I do think it's interesting, like, this is Judge McBurney. Judge McBurney, I think, likes to do a lot of thinking out loud, likes to do a lot of, like, philosophical discussions just to get the conversation out. Like, I think he really enjoys his job. And this, I think his name is Miller, the defense counsel.
Yeah, Steve Miller.
He's had an argument right off his toes, right back for every like food for thought question that McBurney's putting out there. Yeah. So
also Gautam Rao, who is in the middle there, is the lead, the head of training for the Fulton County District Attorney's Office. I say that without comment.
Judge McMurdy. That's a good one, people in court. Also, I saw that James Phipps is a hybrid gang member. So James Phipps has membership over here at Katt Not Williams and is now a new member over at Happily Angry Lawyers channel.
Oh,
That's
thank you,
how you
James.
do it. That is how you do it. The
Thank you.
hybridization.
I should open my channel so I can see what people are doing in there. I'm
So
not used to
on-
the full simul stream thing.
On StreamYard, it'll be when there's a little like paperclip link. For me, that means it's coming from your channel. So anything for you, anything coming from my channel should have a paperclip. Yours won't have a paperclip.
I have 18 viewers.
Yeah, heck yeah.
There we
Guys,
go.
make sure, and Hal's link is in the description. Go flood his comments, his chat, hit his like button. That's kind of weird wording, but hit the like button over there.
I see. Okay, I get it. I'm learning.
All right, so like Trenton, for example, like for me, I see a paperclip on his, but you shouldn't see a paperclip on the chat that we're looking at. And then this one, you should see a paperclip on your end.
Did you ever watch Atlanta, the show? Atlanta? With,
Look, I don't remember anything unless I've watched it 10 times.
Okay. There's a song with paperclip in it, and I was just thinking of that, and it's funny because it's Atlanta.
There you go. There you go.
Why just got somebody needs glasses? Look at
why is
how
he
close
leaning
he's looking at
in?
that laptop.
He's trying
Maybe
to
he's
make
watching the
sure.
football game.
Oh no. Oh no. I also want to say, don't die. Also want to say thank you to Nana Banana, aka BMAC, for being a member for 13 months. Holy moly, that's more than a year. Good to see you. Always good to see you, especially when we're talking about Fulton County madness. Fulton County good times. Fulton County amazing times. There we go. We've got paper clips in the chat. I think that actually, is that
Clippy?
put the eyes there like Clippy? Yeah. Like it. Can they do that? Are they taking the likeness of Clippy? Oh, there you go. You also have.
Ooh, did I get gift memberships? I think.
Yeah.
I'm not. Okay, thank you, Chuck Norris. Man, I
There
love
you go.
Walker Texas Ranger. I love that he sang his own theme song and Walker. I'm way off topic. I shouldn't be talking about this. I shouldn't be talking about the Walker Texas Ranger theme song in a very serious stream about expert witnesses.
Is it serious?
I mean, no, it's deeply unserious, like everything else.
If it wasn't copyrighted, we could just play the theme song in the background while we listen to these arguments.
Look at Miller's face again. I still feel the prosecutors are avoiding eye contact as they do whenever there's something dumb going on.
Like just busy over here, typing on the ceiling, keeping busy.
Wait, Clippy has a Twitter. We're so bad at staying on topic, but
okay,
Clippy has
the URL says
Twitter?
cult, and a cult apparently, because the username says Clippy Cult.
I love Twitter. So I think they should report Abate to the bar. Somebody should do that. I have some ideas as to who should do that.
Yeah, I'm gonna pull this up here because you're reading a comment and reacting to a comment.
Oh yeah, you're a pro. They should. Yeah. It'd be really funny if somebody did that. Oh man, that'd be really funny.
Woohoo! Sheriff Chuck, thank you for the 5 gifted. Look at all this generosity, this hybridization of these gangs. We have to come up. Did we come up with a name already? Because if we did, I forgot it. It can't be Kim. That's too plain. It can't be Jat.
That's true. My feelings about Abate, notwithstanding, when he said defendant married Miss Bumpus, that was one of the greatest moments. Like he was just being messy, and I loved it. I loved
his
it.
demeanor was like, because she's married to the defendant. Like he was ready for that moment. Just ready.
I loved him in that moment. I have no complaints about that. And then it got 403.
Shard wanting to disappear.
Like, that's what I'm talking about. When he got the 403, like I loved Adam Abate that day for sure.
Everybody has a good day, a one day. Thank you so much, Sheriff Chuck. Spreading the love, bringing the gangs together. creating and fostering harmony in these YouTube streets. Yeah, he really could not wait to blurt it out. Just like ready to go. The shining moment. The child who told everything.
That was so creepy. I remember, I think it was Nick Starrow who posted the first thing that I saw about the marriage, and I just looked at the marriage license, and I was like, "What is this? Is there another Caleb Bumpus out there? Like, what is this?"
Sylvia had asked about it. Dennis posted it on X. Nick Starrow did the stream, and then it was
for real.
Was it the following day?
I think it was like a few days passed. I think it was like a couple days where it was.
Was it like maybe it was like a Friday into a Monday or something, like where you have the weekend forcing the break. And then there was the day with Doug Weinstein needing to raise the issue with Viverito in the hall.
That's the last time you'll ever call me a lady.
Good times, man.
Okay.
We are focused.
Look at the deputy in the back. He's very focused too. He's as focused as we are.
You know what? Watching the post-conviction hearings in the Zachary Adams trial, if you guys want a dumpster fire, you miss the Fulton County mess. I think the prosecutorial misconduct gives Fulton County a run for its money over in Tennessee, Zachary Adams. The court officers are sitting there. They're so attentive. They are like tuned into everything Attorney Doug Bates IV is arguing. And I've really never seen that from someone. Usually this is what we see. So that's been a good time. And then we're going to hit play, but every frame seems to be a painting, so maybe we'll get some clips of each of these facial expressions going.
On things jurors told me. Well, that's not science. I suspect that's not the basis of his opinion, but I don't know. And you're entitled to learn more about that. So we need to get the doctor in here during a lunch break or when we're done for the day or something like that. But assume with me for a moment that the basis for his opinion is whatever he'll articulate about human physiology and the flexibility of bones and what happens upon impact. I mean, things that you and I might not naturally understand, that's the basis of his opinion.
So I don't believe it's possible as a person. We're all human. We are our experiences. We are what we've gone through. Part of the reason why I act the way I do is because of my mother and my father, the influence my little sister has had on me and my brother. It would be impossible for him, who's someone who has already experienced this trial, has already gone through the deliberations, has already formed an opinion on Mr. Poole, and guess by the side that he's testifying for. We all know which opinion he has. It would be impossible for him to separate his previous experience with his already an opinion that he's already formed. And that opinion was formed prior to him telling them whatever he has told them already. And so because of that, he can't now say that. And there is, if he wants to say that, then there are.
He wants to say what?
If he wants to say that, like Your Honor saying that this is based purely on expert, whatever. On cross-examination, I should be able to explore those biases. And the biggest bias would be the fact that you've already heard all this evidence. You've already formed an opinion on my client. You were unable to convince 11 other jurors at a previous trial, and now you want to convince 12 new jurors. And because I'm unable to explore that bias.
Why are you unable to explore it? I don't think the state can open that door. Why would you be? What objection could the state make if you decided you want to do that I would sustain?
I think 606B, going into jury deliberations and what happened during jury deliberations prohibits me from exploring that bias that he would have. And because of that, it's inherently is unfair because the biggest thing, the biggest issue with him is the fact that he was a sitting juror and very unable to hear it. Yeah, he wasn't watching the trial as a bystander. He was part of the trial. He spent hours. Yeah, he's already formed an opinion based on the evidence at the last trial. And so trying to say now I'm an expert and this is what my opinion is, I can't explore that bias.
So I follow the thinking, but if Dr. Brogy says, yeah, I formed an opinion because I am a doctor and I know how the body works, and it's the only way. If a body had been in the backseat in a car going that fast, they had the sudden impact it had. For it to end up in the front seat, I would have found 8 body parts and not a whole body. I'm making this, I don't know what he's going to say, but he's the only way for a body to pass from the back seat to the front seat would be for it to separate into multiple parts. And I knew that the moment I saw those pictures, I knew that blah, 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 blah. Then his opinion isn't formed in the crucible of the deliberations. It's formed because he knows some things about the body and impact and whatnot that you and I don't. And if his testimony is, that was my belief as I began to receive the facts in the case, it was my belief during deliberations, query whether we need to talk with this jury about that. And it remains my belief because that's, I'm gonna pretend it's the physics. That's the physics. The only way for a body to get from the back seat to the front seat in that car with those dimensions at that speed would be for it to break into several pieces. And Mr. Poole had all his limbs attached to him. And so scientifically, I'm telling you, it is implausible, improbable, maybe he won't say impossible, for him to have been in the back seat and ended up where he was found. Full stop. That's his expert testimony. And assume for a minute, I don't know, if he's a podiatrist, then it's probably not the right person. But let's assume that he's qualified to say those things. What's the 606B issue around that?
He goes towards the cross-examination. He can say that all day. It's fine. But the jury should be able to explore the weight of his opinion and the weight of, the bias that he has. And the jury's unable to hear the complete story of who this person is because of the previous case.
If the state waives any 606B objections, then what is the harm or the disability that you face in terms of a thorough and sifting examination of the witness?
If they waive that, which
Oh, so I saw this in the chat from Jim. It's Kenneth Poole is the first name.
What's his name? Dennis?
Kenneth.
Kenneth.
That might be the price of admission. I don't know. Like I said, I'm working through it.
if they do, then the issue with that, the next issue would be the extreme unfairness and the structural unfairness under due process. Because one of the issues is,
did you see how little that sip was? What are you doing? I'm sorry. That's not relevant.
No, what was it? I'm nosy.
What was that sip? You have that big cup and you do a tiny sip.
Okay, we gotta watch Mr. Rao. Also another great facial expression over here.
and the structural unfairness under
he doesn't know what he wants to grab.
Because
he didn't even get anything out of that.
Look, but
that
watch his hands. He's trying to figure out what to do. He's like, hold on, one more time.
the next issue would be the extreme unfairness and the structural unfairness under due process. Because
It's a mega fight.
one of the issues is we've known about this trial.
Shout out to Credence and Mikey.
Coming up for a while. Our office filed our and so I don't want to get these dates wrong. Because that's where it comes from. What we've done is they asked for a continuance. They actually had a motion for continuance with respect to the November 5th, 2000.
There have been, I looked at the docket. There have been some, I think the defense actually opposed a continuance after the first trial. On the trial itself. So I know there's been some delay in bringing the case to a second trial. I haven't really looked into the case in any detail, but I did notice that.
Yeah, this is kind of a blind, but again, the issue is so ridiculous that I don't know what contextualization would make this particular issue like, oh, okay, now it seems like a reasonable ask that a juror from the first trial should be allowed to testify and opine to the jury in the next trial as an expert witness.
It just feels like nobody's ever made a rule because nobody's ever tried to do this.
Yeah, like, of course there's not going to be case law because it's not every day you have these two knuckleheads coming up with new things to try. Look, yeah, Brittany Gibbs right on time says this is 100% some Georgia shit. Yeah, maybe Fulton County. I think we can keep it Georgia.
Georgia, okay. I already yelled at Doug about this last night. Do you know how many counties they have? They need to cut too many counties. They have, I think it's 159 counties. They can get away with 50. That's all they need. That would get rid of exactly Gotham. That's a nice suit. I like that color.
Yeah, they are all.
Sorry.
Everyone's dressed really nicely. I think defense attorneys rocking a skinny tie. Skinny ties can look goofy, but I think this is the right way to do a skinny tie.
Yeah, that's not too skinny. Yeah, I was gonna say, like, there are a handful of counties that I feel it's like an 80-20 thing. Like 80% of the weirdness comes from 20% of the counties. Like Glynn County is just mini Fulton. That's like Brunswick, and it's like on the coast. Taliaferro County. There are like 2 or 3 other counties that just always have this stuff.
Were we over in Liberty County for the Casotis trial? Jim McIntyre.
And you're mad.
Yeah, you're mad. And we were watching that. It felt like we were in a different world.
I've watched that world 800 times. It just cracks me up every time.
Also, you know, Gwennon is helping grow your gang over there. Just wanted you to know. Oh, I didn't realize it says in the name, in the comment, gifted, and then the channel membership. We both missed that. We stopped at gifted, and then everything else was a blur. So shout out to Gwennon growing the gang over there. And
yes,
then,
159. 159 counties.
This is a
Prison
Jeremy,
County.
is this a different case? I think you might mean yesterday we were watching the Zachary Adams 2017 trial. So this is different. This is Georgia. This is still, I think they're on day 3. Judge McBurney's live right now. If you want to watch that trial and the original trial, because remember, this is a retrial, I think all of the footage is available. So, but yeah, totally different trial. We're just here to hear this riveting evidentiary novel request from the state. All right, guys, let me hit play.
24 trial. So shortly after this trial, in August.
Oh, wait, what?
Somebody said, Kiss and Pink said Glynn County's Brunswick. That's right. That's where my my next project is. I think you know about Katt, the videotape confession that wasn't turned over. That's from Brunswick, Georgia. The Brooklyn South Housing Projects.
Let's say shout out to Factual Lie, also timestamped. I looked at the stream following this one to find, I found a different issue we're going to hear them talk about, a different issue that happened during the trial, but I wasn't exactly sure where Judge McBurney's decision started, and Factual Lie just sent that. So goat of the day, goat of like a lot of the time, Factual Lie. W's in the chat for Factual Lie, who looks like O'Bailey's if your YouTube is displaying the @ names. Let's hit this play. Another good facial expression going on.
We were getting prepped for this trial again in November. They filed for a continuance because we had sent notice of our expert opinion, our expert witness. They filed for it based upon that. And so since then, they've known that we've had this expert. That was not hired, but that he was there. On
November
May
24th.
30th, we were set on a 2-week trial calendar. My office was prepared. I prepared for this.
This is May 30th of 2025.
2024. Well, this is going back to 24 when they asked for their first continuance in May 30th. And that was on the record on 2-week trial calendar. On June 5th, they requested a continuance by email because somebody didn't have information regarding the witness availability.
So I want the record to be clear. May 30th of 2024. I don't know if that was before we had our trial.
That was right, correct.
So our trial, I declared a mistrial on September 3rd, 2024. So we should talk about events post September 2024. And I've got in the docket exactly what you said, which is we were going to maybe go to trial in November of last year, so a year ago. And then the state on November 1st requested a continuance. You objected, but I entered an order granting the continuance on November 5th of 2024. I think this is, let me look at this special setting date.
The laptop. What?
I don't know. And Adam's like over there like hugging case files while he types over his files.
Oh man. Hey,
this guy's just chilling. Hey Keisha. Oh, good times. Hey Gloria too in the building, saying hello to everyone. I think the jury ended up being hung is what I've surmised. So because they were already deliberating.
It was only after a day too.
Yeah, this is especially.
Sorry, what? You said it was only after a day?
Yeah, I think so. I think that's what it said.
McBurney is like, all right, well, we got to keep the calendar going. Very efficient guy,
My
McBurney
kind of
is.
guy.
Yeah.
I specially set the case for today, at the end of August. So we had one other in November of last year. Maybe we were going to try it. And there was a motion for continuance. I granted that. And since then, it hasn't been a false start of, hey, everyone get ready. I specially said it after conferring with you, and with Mr. Abate, because I think I had put this on what we call our consolidated calendar that a senior judge handles. And both of you, meaning state and defense, but I'm recalling you in particular, Mr. Miller said, look, my client's from Tennessee, a bunch of the witnesses are from Tennessee. A date certain is really, really helpful. And so I said, fair enough. At the end of December 1's our day. Here we are.
Right, but there's 2 days prior to that. So there was the February, and I don't remember the date. I think the solid date might have been December, but there was also the February date in which we were getting ready, and that's when we disclosed Dr. Khan's at that time.
Okay.
When Dr. Khan's was disclosed, Your Honor gave him 15 was because we disclosed him 10 days prior, so that they could get rebuttal witnesses in case they need to get it.
Okay.
There was another date, and I can't remember that one, but it was in between February and August when we went to court, and on that time is when we disclosed, what's her name? The ER nurse, Dr. Or Miss.
See, on August 1, Richard Freeman.
Right, correct. Her. And at that time, Your Honor, they're not going to be, you just disclosed this, they're not going to be ready. We were granted another continuance. And so the fairness of it is we disclose our people 10 days prior, even though statute says we only have to disclose them 5. They're granted continuances so that they can get somebody to rebut these and the people that we disclose. And then on literally the week before Thanksgiving, knowing that I had LOA in that week, they disclosed somebody. And it's not like they said, oh yeah, this is a previous juror. I had to do my own digging to find that individual. And out of the hundreds.
So does that seem kosher? Does that seem kosher?
They always do this shit. They always do this every single time. They wait until
look at their body language right now. Look at the freeze frame.
There's a case that I've been like, this isn't even my case, but this is a case that I've been obsessed with. It was literally the first Georgia case I ever did research on. There was a murder from 2004, and the trial was in 2012. It was a cold case, and by that I mean they just made some stuff up 8 years later. And they disclosed the identity of a witness that they'd known for like a decade, the day before the trial. Like, you've had a decade to tell the defense about this. What are you doing? Sorry, I had to get that off my chest.
No, it is a what are you doing?
Every time.
And like, look at their body language. This is so familiar. Like, you know, with the YSL trial, it was just, well, usually sometimes it would be Adam Abate there, but it would just be different players sitting at the state's table going like this or acting busy when they'd be getting called out about like, hey, you let us know something like yesterday night at 10:59 p.m. or, hey, you never disclosed this thing. Why didn't you ever disclose this over? And they would always be sitting with the same body language.
Yeah, I can't think of anybody Simone Hilton that likes to read through their paperwork when they're being dishonest.
Or she sits with her hands in her head in her hands. It's
so funny when you go back and you watch something that you know they're lying about. They're just all reading so intently, just so they're reading like Gautam Rao reads normally.
And yet they can never make an argument when they don't have the case law ready. Like, occasionally they would have Atkins go up there and argue something, but otherwise it would be like a slow talking plea buffering with love to Judge Glanville. So
Atkins is cool. I feel bad. Like, I feel like I need to have a permanent disclaimer. Anytime I say anything bad about Fulton County, I'm not talking about Christian Atkins.
Not talking about Christian Atkins.
Everybody else. But he's cool. But why are you doing this at the last minute? Like, it's not, and like, you had to have planned this. It's not like you just accidentally stumbled across this expert witness at the last minute who just happened to be a juror in their previous. They turned the crime scene photos in Waffle Burger. Yeah.
Waffle Burger?
Waffle House.
I mean, related, relevant to the case.
I still need to do my video on that case. I gotta try to get an interview with that guy.
With Joel McDermott?
Yeah, I mean, I talked to McDermott after the trial briefly. I'm curious to see if he got to talk to any jurors or anything.
Yeah, I mean, I thought that was a hilarious trial, guys. If you missed that, you get to see Simone Hilton in action doing another closing argument. Like first day, witness throws the state under the bus saying they turned over some VHS to the state. The state's like, no, you didn't. Like, it has all the recipes for a good time trial. Cold case, 20 years old. The victim's family, mom and dad, have killed people previously. Like, dad does the killing, but mom defends the dad. And the state's argument is like, no, we have proof that they couldn't be the culprit here against their own daughter. And our proof is Mama Patton herself and Sister Patton saying, our dad would never do that. That was their proof. That was their proof.
Wait, I gotta fix. Chris Rodriguez is waving at me. Just looks like it might be a lot of hands.
Sometimes YouTube does that.
Yeah.
Repeat the chats.
Yeah, there was a lot of stuff in that case that like the case it looked incredibly weak, but it's even weaker if you like get into the underlying filings. It's I don't want to spoil my video, but the whole thing was crooked. They had no evidence. They had no new evidence. It was just one of the people that we're looking at on screen right now is responsible for the prosecution now.
Just one of them. Just one of them.
It's not the deputy who actually seems to be paying attention at this point.
He woke up.
But
he woke up when he said that they didn't disclose it to us. We had to figure it out ourselves. So let's hit the play button, you guys. Let's hit the play.
Of orthopedic doctors that are in Metro Atlanta, out of the thousands that are in the state, the only one that they can find is one that was a previous juror. It doesn't have to smell test. Besides that, Your Honor, it's like if I wanted to get somebody to rebut that, I don't have enough time to do that because everything shuts down around this time period because it's the holidays. And so I couldn't come up to the court to even verify to make sure that this was a juror prior to it because I was scheduled to be out of the town. I had to cut that trip short because of the trial, but we couldn't even get the actual juror list. So we had to rely on our notes and just memory to even come up with the fact, oh, this guy was a previous juror. And so it has bad faith written all over it because if you knew about everyone that we had disclosed months in advance and you knew about this juror a year in advance, why would you wait till everything is closed and Mr. Miller has his LOA in before you file notice of this person? And don't tell anybody that it's a previous juror, but just put it out there and then let us try to figure it out.
Got it. So you have 606B concerns, which might be resolved depending on how the state wants to approach this. You've got, I'll call it fundamental fairness concerns because of the late disclosure coupled with in the past, when you disclose someone close to trial, the state asked for a continuance and I granted it. Now, are you asking for a continuance or are you saying, I don't want a continuance, but I also want this guy excluded because of, I'm going to say late loosely. I have to do the math if it's 10 days or not, but it's certainly close in time to trial. And there's that I'll call it more fundamental piece of it's just peculiar. I don't mean that
was a big thing.
In a negative way. I'm going to hear from the state in a minute, but it's a strange set of facts that this is a former juror. If this were just Dr. Brogy, who they happened to come across because in the Prosecuting Attorneys Council website chat group, they say, hey, a real good guy about what happens to bodies in cars when there's a collision is Brogy. You should reach out to him. That's a different backstory from this is a guy who was a juror.
Right. And so asking for, if he is allowed to be a witness, one, as Your Honor has wrestled with this, I've also, initially, of course, what do you do? You can't do that. But looking at the case law, there is none. Looking at the statute, it doesn't directly address this. And so if he is allowed to testify, I would ask for a certificate of immediate review because I don't believe he should be able to. And every single attorney, ADA, actual DA that I've talked to is like, you can't do that. Not only you can't do that, Your Honor, when I was a DA, one thing that I learned and one thing, the way that I was trained was that just because you can do something doesn't mean that you should. And this is one of those circumstances where no, we don't have rules that say that you can't specifically have this done. But you know what I mean? Like, it's just like,
Yes,
I kind of do, but
Go off, Jim. Go off.
just why? And why is he taking that tiny sip again? It's even more bothersome.
Look at the facial expression over here.
Okay.
Another good expression.
Just like that's what he's been wanting to get off his chest. He's been making these technical arguments this whole time. And now finally he's just like, what are you doing? Just why? Just stop being weird. Just be normal.
Just sit there and make facial expressions as the argument. Get the old Tennessee accent, the what?
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 Okay.
Oh, a little try. Shout out to Amy E dropping 5 gifted memberships in the chat. I was thinking about you earlier. You guys heard me on our last stream with the body cam video saying that Amy E and also Credence and Mikey, who both popped in here on this stream. Good to see you both. They do a ton of archival footage. So watch some arrest videos, watch some court freakouts, watch some body cam. I'm going to drop both their links. Thank you so much for generously gifting the 5, Amy, and always good to see you.
did you press any of these people who say you can't do that to say, tell me why you think they can't do it? Because I would like to be ready to argue it to a judge. So give me a statute, give me a case, give me something. And what it sounds like is it's more of a just instinctive reaction. Like people might say, you can't let jurors ask questions. Oh, but you can. And that's all right. And the Supreme Court has said it's all right. There's no rule anywhere that says jurors can ask questions. But if done correctly, the Supreme Court has said, you know, jurors can ask questions during trial. I will tell you, many of my colleagues have looked at me like I've got a third horn. You do what? That corrupts the process. Jurors are not fact finders.
Do you need to pull out your drawing of Rao?
Oh my god, it's so weird.
Jim, guys, seriously, if you've never watched a stream where Jim is on his own over on his own channel, I always love to have him as a guest, don't get me wrong. But when he is in his own environment, he brings out the little doodly pen and he draws out exactly what he's either trying to argue or illustrate, or exactly what he's feeling about certain people.
I know what you're talking about. We don't need to go there. But,
well, this was McBurney saying, my colleagues think I have a third horn.
yeah, well, there were horns involved in one of those drawings.
Oh, good times. Let me drop some links in the chat for you guys.
I've got a third horn. You do what? That corrupts the process. Jurors are not fact finders. They are empty vessels filled by the lawyers. That is a perspective. I respect it. Not my perspective. So I'm not disagreeing with you that a lot of people have a reaction of, what? That's kooky. Well, so was the notion of you can fly. What do you have concrete from these people? DA, ADA, lawyers, fancy lawyers, not fancy lawyers, beyond them saying, that's just not right.
Yeah, well, that's the thing, Your Honor. With respect to jurors asking questions, there's case law that allows that.
There's now.
Yeah.
Okay.
There's nothing here.
Okay. But it starts somewhere. And I'm curious what beyond it feeling not right to the people you've canvassed, you heard. I guess you shared with me, like 606B is sort of a toehold, but that might go away if the state says, we're not going to prevent Mr. Miller from exploring that with Dr. Brogy, because you should be able to. He doesn't just come in here as, all I've done is read the documents.
Yeah, but we've already established before we started this motion that we would refer to it, the last trial, as a previous hearing with all of the witnesses. And so now when I'm on cross-examination with him, I'm saying at the last trial, you were a juror. And so the jury's going to hear that. There's no way for them to not hear that. And they're going to give him.
Okay, all right. His face again. Look at Rao.
I'm saying at the last trial, you were a juror. And so the jury's going to hear that. There's no way for them to not hear that. And
he's just like, this is such a ridiculous argument from the defense. Just let us call juror 29 to be an expert witness.
They really think that, like, I feel like it's this insular little thing where they think that they're normal. They think that, like, they're good at this, all of them. Like, this is just the way things are done. And they don't realize that they're not normal. You know what I mean? It's like,
Well, I can say personally, I'm very sad they stopped doing the DA Dispatch newsletters with the Law Corner, where Ra would educate us on key issues.
I was going to cite to that, but then I had to take it out. But I really wanted to the 131 one that I drew pictures on.
I only have one readily available, and it's not any of these two characters. It's Kevin Armstrong.
Wakanda?
Kevin Armstrong.
Yep, there it is.
Yeah, of course it's underlined. I'm prepared. He says, Kevin Armstrong can claim to have been to Wakanda, to have intentionally set part of a house on fire, to have had a rabies scare, and to have driven a modified stick shift around foreign country with only the skills necessary to drive an automatic. So, yeah, there's such good stuff in that Fulton County's newsletter. And they've discontinued it. Probably because we were talking about it on YouTube, maybe. But, you know, who knows. Ooh, Creed says, can he then cross him? Isn't it true the last time he made a decision in this case, the Court of Appeal said the decision is wrong? I mean, that just sounds like chaos on cross. I don't think that would go anywhere.
Yeah, I don't even know like how you Katt Armstrong cannot claim knowledge or expertise. I think
Jim is reading a comment. Jim is reading and reacting.
I did. I should. Yeah, my bad. I was supposed to highlight. I think he's arguing against Steele on Tuesday. I think he's going to be doing the argument on that case.
Oh yeah, that's on the 9th, you guys. So Fonnie Willis has a hearing in the CalCert case, and then there's oral arguments in front of Georgia Supreme Court, and Hal's going to be streaming those oral arguments. So we knew it was going to be some guy, Brian Steele. Didn't know it was going to be the legendary, apparently, Kevin Armstrong coming all the way in from Wakanda, driving a stick shift to make it to oral arguments.
Yeah, this is, I haven't looked into that case yet, but it's a 2016 case, and like 2016 Fulton County was peak Fulton County doing Fulton County stuff. That was the same year that the Darren Mills case was tried and vacated earlier this year. That was... Wake up and yeah. Thank you. I'm glad you enjoy it.
And Gloria, they want him to be introduced as a orthopedic surgeon.
Orthopedic surgeon, yeah.
Yeah, orthopedic surgeon. Which is why we have another great facial expression here. Miller argued, why not just find any other orthopedic surgeon in the Atlanta metro area that they could call and bring forth as a expert witness in this matter?
Yeah, it's just they always do this. It wasn't even just the juror, like you said, they didn't even tell him it was a juror. So like,
they didn't tell him it was a juror, and then it seems like the defense, either maybe right after the mistrial, they spoke with the jurors, or in relation to discovering this issue, they went and spoke to at least one other juror, and that juror gave some type of indication that Juror 29 was strongly urging us to convict. So the defense, at least at what they're arguing in a motion, this little bit that we looked at, has a reason to believe that Juror 29 would be... How can you decipher that this juror wouldn't just go up there and say, hey, I'm basing this on my expertise, but has this in the back of their mind because of what they deliberated on for trial 1.
Do you then have to call the nurse and have her be like, he's crooked?
Call the whole jury back. Bring all the jurors in. Make them all expert witnesses. Put them in the witness stand at one time. Oh, goodness. All right, so let's see. Eventually, Rao's going to have to argue. We're almost there.
They're going to get him, or it is possible that because they are aware that he's a juror and that he is so gung-ho on coming back to court and testifying against Mr. Poole, that his testimony is going to have greater weight than anybody, any other expert, any other witness that was here, because he could be seen as quote unquote so passionate about this case and all of his findings within them. But no, I would say that everybody's instinctive I would agree is you can't do that, but there's nothing saying. The back and forth that I've had with everybody is similar to what we're having here.
Okay.
There's nothing concrete saying that you can't do this. So it also comes back to just because you can do it doesn't mean that you should.
Okay. Last question, and then I'll hear from the state. Tell me what is prejudicial to your case if this jury learns that there was a previous trial.
If the jury learns that there's a previous trial.
How is that bad for you or for Mr. Poole?
Well, not only was there a previous trial and we had a hung jury, but there was how it's prejudicial is that there was a previous trial, and are you talking just previous trial in general or a previous trial and then he's testifying? So I know how to.
So my question is, once you confer with co-counsel, and then I'll tell you my question. I'll tell you my question, then you can confer. You raised a point I hadn't thought of, which is, if I want to be able to thoroughly cross-examine him about his origin story, because he's not just a doctor off the shelf, he was a former juror, I am revealing to this jury that there was a trial before. And as you pointed out, we just finished a discussion about, let's not tell this jury that there was a trial before. Let's talk about a prior hearing, a prior this or that. But that got me thinking, why do we care that the jury learns that there was a prior trial? And sometimes it's very different depending on the side of the V you're on. So I'm less interested in the state's perspective on that right now. But you raise that as this would be bad, Judge. I'd have to let the jury, in order to cross-examine this guy the way I should, and I agree with you, the jury's going to learn there was a trial before. And then my question is, so what?
I think they might give the witness too much weight. They're like, oh, he's been in our shoes, so he knows what we're going through.
Yeah, or even that, like the notion that the state has so much evidence that they were willing to bring this trial twice.
Yeah.
So why would they go through the energy to do this twice if they didn't have a valid reason? So. Oh, that too, GV. The jury doesn't appreciate the finality of their decision if they think they can just do it again.
Yeah, we're brainstorming out some good ones here. I like it.
Yeah. Love the crowdsourcing. Love the chat. This is Judge McBurney that we're listening to. So again, it's not atypical for Judge McBurney to ponder and ask questions out loud.
There was a previous trial. At that trial, they will know that it wasn't a guilty verdict because you're back here again.
Do they know it wasn't a guilty verdict, and then there was an appeal, and it was a successful appeal? We certainly wouldn't get into why are we trying it again. But this is why I'm pressing you on it, because these aren't lawyers necessarily. They might think there was an acquittal, and the state appealed the acquittal. Can't do that. And the higher court said, oh, Miller and McBurney made mistakes. The state gets a second bite at the apple. They might think that it was a conviction, and it got tossed. They might think hung jury. They can think lots of things. We don't go to why there is a second trial. It's not what would be explored. In some ways, this wouldn't be the right juror anyway. Like he's the right person. He just knows he's here to testify. So keep going.
Right. So it would be specifically on that. It would be the fact that we're back, and so the state is still pushing the button on this case. They are still pursuing it and trying to go after Mr. Poole. And so there would be a question of the jury of like, they keep on trying to go after this. They're not giving up on it. Maybe there is something there. And so that's where the prejudice. He is going to be he's going to be somebody that's going to have that insight. I'm sorry, y'all. Right. And there's no other witness that would pose that threat that would bring up, the fact that there was another trial and that the state keeps wanting to fight these assholes.
Right, at least purposefully, correct. I mean, your witness could inadvertently spill the beans and say, well, at the last trial I said, and we'll have to work through that. But this is one where you've explained, well, no, I would want to pierce that barrier that we're constructing so that the jury knows more about this guy, that maybe he isn't a neutral person because he was part of a jury and here we are again. And now he's talking about some technical things. So I understand why you'd want to explore with him that he had been a juror before, which undoes this protective effort of let's not let this new jury know there was a prior trial, which led to my question, which is, well, why? I just sort of assume no one wants to talk about the fact that there was a prior trial, but maybe that doesn't matter. But you've articulated that it in theory could create the sense amongst the jurors that, well, Mr. Poole must be a bad guy because here the state's trying again. And if he was a good guy, they would give up after the first one. I don't know that's a super compelling argument, but I get it. I just struggled to come up with a compelling argument as to why it's disadvantageous to the defense for the jury number 2 to learn that there had been a jury number 1. Other than it's not relevant.
Yeah, I mean, you can sidestep this whole thing by getting any of the other thousands of doctors. You don't have to speculate.
It doesn't need to be Juror 29. Why is it with Fulton County trials we have reason to know different juror numbers? Like, jurors become relevant to the evidence presented in cases for the record. Just Fulton County on their own island again.
Farmer, yeah, seriously.
I also that was one of my facial expressions. Should we grab this one from Rao right now? What he's doing on screen. He looks like a dinosaur. I'm gonna screenshot it.
I feel you.
Yeah. All right, we're gonna hit play.
All right. Okay. Yeah. And so that this verdict point, it kind of follows what Your Honor is saying. That, like, witnesses, I mean, the jury, they're all late, and so the thing the thoughts that they want to have when they hear about this other trial, they could go either way. But we shouldn't even put them in that position where we have to decipher if they're going to be more pro Mr. Poole based off of this witness or pro state based off the fact that they keep biting the apple. It's a position that no juror has been in before, or that we know of, because there's no case law on it. But it's also one that not only is unfair to Mr. Poole, it's unfair to the jury, it's unfair to the whole. Where's the lady of justice at around here? Like, that's why we have this here. It's because it puts the jury in that position, because now they have to decipher between that. Why should we care that Mr. Poole is here again?
Okay. Let me hear from the state, and then I'll circle back to you. Mr. Rao, you're standing up reluctantly. You're going to argue this? Okay.
So I'm not aware of any legal precedent that would preclude Dr. Brody from testifying. I don't believe Rule 606A or B theoretically applies in this particular case. And the bias that what I believe the defense is postulating to the court is the fact that Dr. Brody had an opportunity to sit through all the evidence and form an opinion based on sitting through and hearing all that evidence, and then deliberating with other individuals in the jury. From my perspective, I think the deliberations that you have with the other juries are of no legal consequence as it relates to testimony any more than it would be if Dr. Brody was not a member of the jury, but had an opportunity to sit through the trial and discuss it with other experts in this field. And let's say 10 of the other experts came to the same conclusion, one expert did not. It doesn't have any legal relevance as it relates to his testimony. So I'm not aware of any precedents or.
I think there's like and it's not completely related. It's not the same type of comparison, but there's a reason that appeals courts, when you get to the appellate level, there's some deference given to how the judge, who was sitting and observing everything happening in the courtroom going down, how they weighed and how they applied their discretion. So I don't see why a similar reasoning couldn't be applied to a juror that was able to sit within the proceedings, which would be a different perspective than a non-juror sitting in the gallery, a different perspective than a jury that didn't make it to deliberations. You know, I feel like there should be an application of that same type of reasoning that appellate judges give the trial judge. And it's not the same to just say, well, they can go watch everything on YouTube. So, but I didn't really hear that like granular hashed out. But
it's just such an annoying argument. He's like, there's no law that says you can't do this. It's like, there's no law that says a dog can't play basketball. It's like, it's Air Bud reasoning.
Is that a brand new sentence? It's Air Bud reasoning? Look at the gems you're getting from this, guys. Make sure if you're on this channel that you're showing on Katt Not Williams, you're also showing Jim some love, because we got to keep him going. Like, what a gem. Air Bud reasoning is hilarious. Also, thank you, Gwen, in being a member for 6 months, saying the judge needs to ask, like, why this expert? Why not like any other orthopedic surgeon? And I don't, I feel like maybe what they want the orthopedic surgeon to testify to could also expand beyond an orthopedic specialty. I'm not really sure of the issue, but find someone else.
We need the
And then
crash daddies.
The crash daddies?
Yeah, they'd take care of this case in a heartbeat.
Oh, man. Maybe just show them this clip and they'll walk in and say, Your Honor, please let us end this. Thank you, Factual Lie, for being a member for 18 months, and the reminder to hit the like button wherever you're watching. Big, big thank you. Brittany says Air Bud was my favorite movie ever. I love that. I love that. Tay Biz in the building, another one of my favorite YouTubers. Been on a slight hiatus there. I hope to see you back creating content soon, and glad you found us for the Fulton County stream. Always seems to bring us back together. Oh, there's some new Laura John Oliver video about Air Bud. Oh, there's a new Air Bud. Oh boy. I don't know if I have faith in that. I'm scared.
What's he playing now? Like cricket? Like what sport are you even playing now?
It's like the Now albums that are up to like Now 128. Oh man. Oh, holy moly. Oh my goodness.
Okay.
Let's let this guy get this argument off his chest.
Case law statute that would preclude him from that perspective.
What's he going to say?
He's going to say, based off his a review of the medical records, the autopsy reports, that it's the injuries that Mr. Poole sustained are more consistent with that of having been in the driver's seat, and Mr. Minor's injuries are highly inconsistent with the injuries of the driver, essentially. And that's based off.
And remind me, there's a second victim. His injuries, no one's disputing he was not the driver, or?
That's the relevance. I think on impact, there's consistency if someone was the driver because of the way their feet would be positioned on the pedals and a certain force of impact, the way your bone might fracture or split because of your foot being at an angle as if it's on a pedal, would be consistent with someone being the driver. And there's a dispute over whether or not Mr. Poole, the defendant, was even the driver, because nobody actually saw him or witnessed him in the driver's seat of the vehicle.
Are you serious?
So now I'm starting
guy driving. That's where we're at. Nobody even knows that he's the driver. And that's how they're going to prove it, by getting a juror from the first trial. That's where we're at. I'm so glad I didn't research this case. This is incredible.
Oh my goodness!
You don't even know he's the driver. You're getting an orthopedic surgeon. I don't even know if that's like within their area of expertise, is like accident causation or injury causation. But that aside, what was the first trial if you didn't have this guy?
Are we gonna have to do a rewatch? Oh my goodness! I think we might have to do a rewatch. I think they were short trials.
Fulton County is so bad they made me quit my job. They're so bad. I was making so much money, and it was.
I don't mean to be laughing.
My office on the right, there was the Hollywood Hills and the Hollywood sign. Then on the left, it was like Santa Monica and the ocean, and I was like, no, this can't stand. This is great and all, but they're being really stupid over there in Fulton County.
There's one county, the final boss county out of all the Georgia counties.
I was talking to my guy from Glenn County the other day. I'm like, man, I'm telling you, Glenn has some Fulton tendencies.
Well, really that's why you said it's mini Fulton, right?
It is.
It's like the mini croissant. Oh my goodness. Oh my gosh. Guys, don't tempt me with a retrial, but I'm tempted if it's short. Because what is going on? And okay, so this is a slip. So in trying to look at, they argue today and Judge McBurney makes his decision the next day. And in trying to queue up that clip, which thankfully Factual Lie did that for me, right in the beginning, they're discussing a plea deal that was offered. So just for an additional sprinkle, there's felony murder charges. Well, yeah, no, not Michael Sprinkle. There's 2 felony murder counts And the mandatory minimum would be life, a life sentence. And I heard the discussion at the stream that starts after this one that's what Adam Abate was willing to offer Mr. Poole. Take those felony charges off the table and not make a recommendation for sentencing. They would leave it as a non-negotiated plea otherwise. So the sentencing decision would be in McBurney's hands. So another interesting thing, like, this is a retrial and we're like, whatever. Life as a minimum or not life, who cares? We just want to try this guy.
Yeah.
Just very Fulton County.
Are they sure they know the right charges this time? Sorry, I couldn't help myself.
You know what? You're going to look at this paperwork, aren't you?
I don't want to, but I probably will.
Look for a gym update, maybe. All right, let's get to Mr. Rao. I've got a lot of good clips from him already today. There's a third one I got to upload.
Trial, I don't believe that's the defense's position.
It's Minor or Poole who's behind the wheel.
Correct.
Okay, so person number 3, we don't get into what his injuries indicate about where he was in the car.
Correct.
Okay.
And in addition to the review of the medical records, obviously his expertise as an orthopedic surgeon, having worked at Grady specifically as it relates to performing trauma care on patients, would be the basis of his testimony. The bias that's being postulated to the board is the fact that he had access to the evidence, no different than any other experts who did not sit on a jury or sit on the trial and formed an opinion based on the evidence.
Except that this particular expert actually sat with all the jurors and debated with them. How do you guard against, is there even a way to guard against, or option C, does one need to guard against whatever was learned, imparted, gathered from the deliberations, which is different from consulting the medical textbooks or talking to colleagues?
I don't believe it's relevant as it relates to this particular trial. Any opinions that other people had as it relates to listening to the same evidence that Dr. Brogy did isn't relevant. What's relevant is what Dr. Brogy had access to as it relates to the evidence in this particular case, the same evidence that everyone else had access to in the last trial, and forming an opinion based on that evidence. And again, the purpose of Dr. Brogy's testimony isn't to be, I sat on this jury, my position was clear. Maybe someone else's position wasn't as clear. And that's why I'm testifying here. I'm an expert in this particular field. I had access to this.
This argument is, we had diverse thoughts on the jury, but I'm the expert, and this is what I felt. This is this to me like cuts across like a complete swipe across letting the fact finding and deliberations and whatever should be within the kin of the jury stay within the kin of the jury. You're saying that this juror alone is the expert, even though others did not feel the same way they felt in the previous trial.
Yeah, he's just being slick, but like, you know what I like to compare these situations to? It's like, you ever play hide and go seek with like a small child? And like they're hiding under a blanket, but their legs are sticking out. And
like you can just let them, they think that they're hiding really well.
That's what this is. Like, we all see what you're doing. Like, we know what you're doing. Like, you're being weird. You're being shady. And even if we don't know exactly what your plan is, like, nobody does this.
Yeah, and that's why there's no case law.
Yeah, exactly. Nobody's ever done this before.
Yeah, why have 12 jurors? Why do we need 12 jurors when we could just have juror 29 at every trial? Just call him for every trial.
I can only imagine if it comes out that it's got to come out that he was a juror, right? Like, even if they try to know, it's got to come out. He's going to say something.
He's going to be like Dennis on the stand, just waiting to talk about just getting released.
Oh man, I'm so excited about Tyrone. Sorry, I should. If in the Darren Mills retrial, they're gonna have to try to qualify him as an expert again, and I can't wait for that. Brian Steele is gonna eat his lunch.
Oh, I can't wait! Please stream all of it. Can you stream those?
What judge is it? I don't even remember. I'm not sure if I can.
I mean, maybe it'll be a different judge because of some type of conflict or something. True. So you don't even know if maybe it's not settled stone yet. So
lyric testimony in that case was one of the dumbest things.
Was that the AK-47 one and the nickname with AK in it? and how something.
Yeah, that one too.
Oh, that was a
like
separate
different
issue.
thing Yeah, that was a separate issue. But he said that like future lyrics were just Darren Mills's confessions.
Future knew what Darren Mills was going to confess to.
And like he's like
Future's the GOAT.
he wasn't even saying that, like Dennis didn't even recognize them as lyrics. He was like, these are just their confessions. And I'm like,
oh, that sounds like Usher.
There are a lot of AB rhyme schemes in this confession.
Didn't he say his gang training was because he read like music and rap magazines? And yet he couldn't recognize Future
in Atlanta. He like, I can't even think.
And Future was part of what they had to analyze for the Young Thug trial, because they were trying to say that the cover album arts and the collaborations were indicative of some gang war.
Oh,
so how are you unaware?
He didn't recognize Lucci. There's a Lucci song. They're in the middle of a RICO investigation of the guy.
And this is one of the mentors that is this it? Yes, I picked the right one.
Yeah, that's
from Viverito. I came up kind of under the guidance of Kimberly Underwood, Mark Belknap, and Tyrone Dennis, who are all well-versed in the YSL and YFN world. What did you just say about Lucci?
Oh, I got some shit. I got some stuff on Belknap too. He's on my list too. Yeah. I don't know if I'll get to use it, but I got stuff. I got stuff on Belknap.
All right, and Aaron says that the case is in front of Dunaway. Judge Eric Dunaway. So
I don't really know Dunaway that well.
I think a lot of people just know him as the guy with like the clear, thick-rimmed glasses for like one of the offers of plea hearings in YSL. But yeah, something doesn't pass the smell test.
It's an odor of mendacity.
Yeah,
I've never
odor of
said that
mendacity.
before. I've always wanted to say that.
You've never said that before?
No. I gotta be different. I feel like it's too popular.
Well, it's faded out of popular usage, so now's the time. Maybe we'll find some new sound bites before this is over, depending on this argument.
Particular pieces of information and evidence, and based on that, this is my opinion.
Any reason, unless his opinion is way out in left field, you all didn't, after having heard from him or whatever the process was, you didn't reach out to another orthopedic expert to avoid the structural baggage he brings with him?
There wasn't a belief that there was structural baggage as it relates to prior jury service. Again, from the perspective, there's no case law to support any conclusion of this testimony as it relates to an expert witness in the field of orthopedic surgery. The conversation that he had with other jurors are of no legal consequence. There was no verdict rendered. It's as if we started back to square one. And the fact that he had conversations with other people based on his review of the evidence, no different than he would have been in the same position to do if there was never a previous trial when we were trying this case for the first time. If he
the audacity to even say that. There's no baggage at all. Nothing to see here, Your Honor. Right.
Reset the whole panel of jurors.
Baggage. You still have baggage.
Why don't we use the same panel of jurors for a retrial then? If, like, his argument would also reason to be that retrial we could use the same 12 jurors that couldn't come to result the first time.
Like, the fact that we're here having this discussion is evidence of the baggage. There's clearly baggage.
Oh my gosh.
Okay. All right.
We made it really far since we unpaused.
Okay. Yeah, maybe like 6 seconds.
I had conversations with his spouse.
Oh, sorry, what?
I just love the angry pen fiddling.
Yeah, over here.
It's fantastic.
Position to do if there was never a previous trial when we were trying this case for the first time. If he had conversations with his spouse, with his children, with other experts in the field, or just friends and colleagues, it would be no different as it relates to his testimony in that regard.
If he testifies and Mr. Miller or Ms. Bird wants to explore the fact that he was a juror in this case before and go wherever they think that might take them, do you envision imposing a 606B objection?
I think that would be appropriate, given that any conversations that he had with those previous jurors aren't relevant as it relates to his testimony.
So let me ask it differently. First, if I'm going to pretend Mr. Miller's doing the cross, but it could be either one of the lawyers. His first question is, Dr. Broggie, You were a juror on the first trial of this case, weren't you? Are you objecting or not objecting to that question?
I think a 401 objection would be appropriate.
Why shouldn't Mr. Miller be able to explore that experience as a potential source of bias for Dr. Broggie? You didn't like.
Did you want to respond? Are you speechless?
Yes. What do you like? That's he was just saying it's no, like, I can't even figure out how to start. He just said 6 seconds ago that having the information from the jury can be part of the basis of his opinion. Like literally like a sentence ago. And now he's saying that he's saying that Miller can't ask the witness about the basis of his opinion, which was the jury service. So now he's saying that he can't even get into the basis of the expert opinion. That's the whole thing you ask expert witnesses about. Like, what? It's like, it's breaking my brain.
They're accidentally gonna like, oops, we forgot that we were calling him as an expert and we're accidentally treating him as a fact witness.
Yeah.
And fact-finding witness.
It's like they found Peter Steele said it really well. It's a novel way to use sword and shield. Yeah, it's like they are getting a biased witness, but they can't explore why he's biased. It's like they're shielding the bias behind the fact that he was a juror. And they know exactly what they're doing. They're like little stupid kids with their legs sticking out of the blanket, thinking they're getting away with everything, being all slick. Like, we all know what you're doing. It's just disgusting. If you wanted a fair trial, you wouldn't do this. That's the bottom line.
The collection is growing, guys. Oh, chat. Imagine one day, like, we do a chat reunion, but it's us all going to watch a Fulton County trial together. We do a chat meetup, but it's us just sitting and filling in one of these galleries.
That'd be funny if I just had a hearing, you guys. I just turned around and it was like Katt and like 30 people from YouTube just sitting behind me. Might throw me off, actually.
Well, at least you can look forward.
Yeah,
we'll bring you pens. Aaron's gonna bring a tomato. Yeah, this is it though. Smart Towel's right. Every time I think, do they get any worse? They do.
They do this. They've been doing this for years. They have like a mistrial and they bring back there was a case, a defendant named Curtis Clark. It's from like 2004, I think. And he had a mistrial. There's like no evidence. And then right before the second trial, they pulled somebody out of Rice Street to say they saw the guy do the shooting. And it's like, what are you guys doing? Like, come on.
I think Destined to Be just hit a light bulb for me. Destined to Be says, are they paying him as an expert, or is he suspected to do it? Is he supposed to do it for free since he was a juror? And that would make me a different first question. Like, were you a juror in the first trial? Have you ever testified as an expert witness before? Like, does this guy even have experience testifying in court?
Yeah. Yeah, that's good. Like, say he says he's doing this for free. Like, why did he do it for free? Because I think he's guilty from being a juror in the first trial. Like, there's just no way.
Oh, shout out to Moontunk. Free Moontunk. KP says, don't bring a banana. Oh, man. We need more screenshot. We made it another 6 seconds.
You can lie through your teeth for an extended period of time. Just don't eat a banana.
Yeah.
Way my client testified, did you? You felt like he wasn't respectful of the prosecutor. I know what Dr. Brogie's going to say, but shouldn't Mr. Miller be able to explore that? Because Dr. Brogie's not a stranger to the case. It would be a bizarre question if Dr. Broggie just was a Grady physician and he looked at the materials and then Mr. Miller starts, you don't like my client, do you? I would think you would object and I would shut that down. But that's not who Dr. Broggie is in connection with this case.
Yep.
I mean, I guess one way to skirt around it, if we want to avoid a previous trial, is you observed a previous hearing.
Look at his face.
We need to watch that again.
I was gonna rewind it, but the way it froze gave a whole new. This isn't real. This isn't real. Oh my gosh.
Oh man. I'm a big Steve Miller. I didn't know who he was before this, but I'm a big fan.
Oh my gosh.
You don't like my client, do you? I would think you would object and I would shut that down. But that's not who Dr. Broggie is in connection with this case.
I mean, I guess one way to skirt around it, if we want to avoid mentioning a previous trial, is you observed a previous hearing
It's like the
and developed an opinion based on that you don't like my client, or something to that effect. Maybe that could
He's
potentially
checking for
overcome the
the
401
steam.
objection by the state, but I don't think the fact that there was a previous trial, that he was a juror in that particular trial, is particularly relevant as it relates to his
Of course it is.
testimony. Again, I've not heard anything to say that the bias that Dr. Broggie hypothetically has in this case is based on anything other than the fact that he had access to the evidence, same as the defense's experts. I understand there's a small caveat in the fact that Dr. Broggie was a juror in this particular case.
Or big caveat, but
Oh, sorry.
That's not the
You said
point.
pause?
It's about questioning him on the bias, not about whether he has a bias. The source of the bias. He's completely missing the point. I mean, he knows the point, but he's not answering the question.
Look at the face.
Same, Steve. Same, Steve.
Oh, I'm having a whole collection forming here of just screenshots. Oh my gosh. Sweet Lady Sugar also says, what happened to the Moonton case and the Jeffrey forfeiture case? So forfeiture case, state lost their appeal. Appeals court didn't even want to hear the issue. So
No, I didn't even see that, but that makes sense.
yeah, I'm pretty sure they didn't want to hear the issue. So that's done with
Yeah.
the forfeiture.
It was silly. It was silly.
And then, do you want a 411 Moonton happenings?
Just waiting. It's set for the December term of court, so that means it could be any time between now and April. Hopefully sooner, because there's not going to be any oral argument. But yeah, just waiting.
Yeah, and big difference because, like, guys, the reason, don't get me wrong, I'm still going to keep doing a deep dive on the Zachary Adams trial. There's like so much hot mess over there. But there's such a stacked roster and docket of things happening this week and next week because court calendars schedule everything right before the holiday, and then they do nothing for like a month. So,
Okay, I just checked the sledge thing because I was afraid something came down. No, nothing. Still no news. Not
Still
on
no
the
news.
fourth day of the term. I'm hoping it's before Christmas, but it's
Yeah.
just, I don't know if that will be.
Yeah, exactly. Waiting in custody. When they were happy to rush him out when they needed a plea deal right after Christmas. So
Man,
but
I was gonna say,
I had that footnote that I had. I think I showed it to you. The one about the magical December 26th. So they had Moonton in jail on Christmas, and then they started plea negotiations on the 27th.
yep.
And I was like, December 26th must have been a remarkable day.
Well, and all that series of email exchanges was like the 36 hours ish time frame before the plea colloquy.
Less than that.
So even the less than that. That's worse.
Less than 24. Less than
So
24.
even the sudden rush to negotiate, it's not like they were trying to negotiate from when what was the date that they filed that notice of?
December 7th, I think. There were two notices. There was the
recidivist.
first 10 days of December, depending on which one.
Yeah, so they initiate, hey, we're gonna like put the court on notice to make sure sentencing tables you look towards higher ranges, and then a few weeks later they suddenly start negotiating. It's not like they were trying to negotiate the whole month. So you guys already know
I love his face. Just Steve Miller's face. Just look at that.
I just screenshotted this too, Ral. We hit play and it like moved him to this. So we're gonna have a whole bunch. And Abate looks a little sick. Let's see how many more facial expressions we get before. What do we have? We have like 17 minutes left.
that distinguishes him from a defense medical expert.
But not to the point where I believe that there's a preclusion of his testimony and that there needs to be any mention that he was a previous juror. His opinion is his opinion.
Okay. Thank you. Mr. Miller, question, and then I'm happy to.
How do you not get that? I mean, you do get it, but okay. Okay, I'm sorry. I'm going to stop talking. It's only been 3 seconds.
Look at the head hung back here. Maybe just looking at a phone. Who knows?
hear any response you've got to what you heard from the state. Do you have there've been a number of names that you've added over time to your witness list, several of whom are experts. Are any of your experts people who you expect will opine on the nature of the injuries and the consistency of those injuries with being, well, let's start with Mr. Minor. Are any of your experts going to say, actually, the injuries Mr. Minor sustained are not inconsistent with having been the driver? That's sort of the easiest, loosest conclusion someone could make.
Are any of my experts want to say that his injuries are not consistent with him?
Not inconsistent. Not inconsistent. That is a super conservative expert opinion. Someone would say, I'm not saying he was in the driver's seat, but those injuries are not inconsistent. If his only injury was he broke his right arm, and an expert would say, that's inconsistent with being the driver. You'd have something on your chest. But an expert could come in and say, his injuries are not inconsistent with being in the driver's seat. Better for you is an expert who's going to say they're consistent with being in the driver's seat. You can answer either one of those. Do you have a medical expert who's going to come in, basically the impact of his or her testimony will be Minor was in the driver's seat?
Yes.
Okay. So this is the state's rebuttal expert. Why do we have to give you a ton of time to get a rebuttal expert?
Well, specifically for this expert, like the state, jurors have reached out to my office. One in particular, which is why when I saw Dr. Brogy's picture, it clicked so quickly. One in particular said that she was one of the holdouts, and that he specifically during the deliberations was who she was bumping heads with. They were having it out. And so I don't have her information. I was literally in Target with my.
Look at how busy they look over here. They don't know any of this. They have no reason to believe that the person they want to call as an expert witness, as a rebuttal witness, which I think is to get around the late disclosure, right? They're going to argue to get over the late disclosure of this witness issue by saying, oh, it's rebuttal because they introduced someone on their list, so we're not really late. They're going to alpha omega bookend this case with this former juror who's going to go up there and say, I'm an expert. And then they're just sitting here acting like that's not the gamesmanship that they're trying to pull off.
Yeah, that's the bottom line. I mean, if you wanted a fair trial, you wouldn't do this. That's really the beginning end of it for me.
Yeah, why is he the only one with that opinion? And I would say, yeah, sir, rebuttal, maybe this is the good example of why that should be allowed. Because you're going to end cap your case with an opinion right before deliberations from someone that previously deliberated.
And she stopped me. I didn't recognize her. She recognized me. And that's what she disclosed. I don't have her information. I don't have the number. I can't call her. But she is a nurse as well.
When did she disclose this to you?
This was the beginning of this year.
Okay, long time ago.
Yes.
Okay.
Which I take it, Dr. Brogy probably reached out to them a long time ago.
I don't know.
I mean, I don't know. But what I do know is that this trial happened a long time ago, and we're not hearing about him until right before Thanksgiving.
Okay, you covered that point. So what's your point about this mystery juror who I'm sure we could figure out her name and whatnot, but
I should be able to call her.
okay. And
Yeah, I should be able to call her.
To do what though? I mean, 606B doesn't disappear. It may be that it is more loosely applied if Dr. Brogy testifies, where you could say, well, you were a juror and this and that, but this juror you're talking about will come in and say, oh, let me tell you about deliberations. He was angry about this and that.
Well, not necessarily let me tell you about deliberations, but she would be able to help with the impeachment of him as far as his biases towards Mr. Poole. We also
but this just goes into this compounds the issue of you're going to have this initial expert, Brogy, get up there and you have to be able to confront him on deliberations.
Yeah.
Because to be able to confront him with this other juror on the bias, we deliberated together.
It's just so messy. Why? I mean, I know why, but it's so messy. Just be normal.
To me, this seems like to even argue this at all is just saying we want the conviction and don't care if it would be an appellate issue.
Oh, for sure.
So,
well, the move, get the conviction, and then if the appellate court reverses, you just offer him a plea deal that'll let him out that day if he pleads guilty to a lesser offense, and so you don't get sued on the back end. It's their move. It's what they always do.
Look at his face. Oh. And Mr. Big Play Bray says, question, did the prosecutors do an exit interview with the jury? Because the person could have told them, you should have said this to prove your case. So it seems like this was not obtained through some type of like after deliberations, they go in and they can go to the deliberation room and speak to anyone that wants to speak. It seems like this came about separately because defense wasn't present whenever Juror 29 initiated whatever communications to somehow get down this pathway of being added to the witness list in this trial. This guy was out, the defense was out of the loop on all of that.
Yeah,
So.
I don't know if there's the way of discovery in terms of like communications between the state and like I don't even know like what rules would govern discovery between the witness and the state, given that he was a juror.
Well, and then this might not be such a big deal, but what about a case where like everything about the jurors is impounded for like a long time? It's not just like a regular approach. I don't know.
Clear when we use the word bias, someone who looks at the facts and says, I think he's guilty, does that make them biased? Or are you saying that this woman said, he was saying things that I thought were inappropriate about Mr. Poole, I'll make this up, didn't like his beard and thought he must be guilty because that would be a bias that I think one could explore, but it's not a bias to look at the evidence and say, I think the state has met its burden. That's
is that part. It's the part that explores their discussion outside of the evidence that was given.
okay. So anything else you want to add about this juror that you're telling me about?
I would really say that if he's going to be allowed to testify, I would ask for a certificate of immediate review so that we can, one, get into the basis of his testimony, but two, get some case law and some precedent on an issue like this, because it is nuanced in the fact that the law doesn't say that you can't do it, but it also doesn't say that you can.
Okay, got it. I will think on this one some. How are we looking outside? Any jurors yet? Nope. Gosh. We will get an update from them. Mr. Miller, anything else you want to cover before we start jury selection?
As far as, do you want to wait on motion in the meetings?
Oh, no, I'd like to talk about anything and everything, but I don't see any. You've
I
got
think that rounded it out here.
this just in
for this
on the
issue.
heels of saying the state files things late.
Well, I haven't seen any file on that. I'm sure they have.
I bet not.
Do you? No.
They do file things late. What do you mean?
The only other one would be testimony that Mr. Poole is referring to Mr. Poole as a driver in the case without that first being proved.
Hold on one sec.
Oh, I think they're here.
Oh, they are here now.
The papers will be here.
Okay.
Report.
He just looked at, because just funny timing, like 30 seconds ago, I said, no jurors? Nope. But he just popped out, so he'll get that. All right. Don't refer to Mr. Poole as the driver until it's proven? I mean, doesn't that mean we have to get a verdict and then what, they can go and tell the jurors, yep, he was the driver?
Essentially, Your Honor, it's our contention that, well, it's not contention, like they have to be able to prove each element of the indictment. Part of that is identification. And so for them to state that Poole is the driver before they've been able to identify him as the driver would be improper. It would be, we argue that it would be assuming facts that are not in evidence, unfair under 403 and an improper opinion under 701. The biggest thing in this case is who was driving the car at the time of the chase. And so it's an ID issue. And so for them, they don't have a single witness that can say, I saw Mr. Poole driving this car. They don't have that. And because of that, it is a question for the jury and shouldn't be just, the jury shouldn't be hearing it over and over again. The driver is Mr. Poole. It had this repetitive nature of it. And then when they go back to the deliberations, they still remember the driver is Mr. Poole, because it hasn't improved. And so we would object to that conclusion in reference to Mr. Poole as being the driver.
Okay. Any other motions?
There was a picture of a previous accident where Mr. Poole's car was on a pole that was brought up during Mr. Poole's cross-examination. We would object to the relevance of that. It's from a...
Oh, I'm remembering that. Was it the same car? There was some, I'm gonna call it a wipeout, and the car was sideways or something. There had been an accident.
That's correct. We would object to that coming in. Not relevant.
So it sounds like he took the stand in the first trial.
Yep.
And factual lie said it was 4 days, including deliberations, first trial, trial 1.
Okay. Anything else? All right.
All right.
I
So they start, oh wait, does he make any comments?
am going to let the state refer to Mr. Poole as a driver. That is something they have to prove. But to me, that falls in line with referring to someone as a victim, when in the end, the state's going to have to prove that something wasn't self-defense, in which case it's not a victim. Referring to the defendant as the defendant, the accused, a murderer. The state has historically been allowed to do that in criminal trials. I will make plain, as I am confident you will too, Mr. Miller, that nothing is settled until it's proven beyond a reasonable doubt. But the state's theory of the case is that your client was the driver, and they can refer to him as that. It doesn't make it so just because they say it. What about, Mr. Body, this photo of the car on the pole? And to be clear, it's not balanced atop a flagpole. I think it is on its side or somehow has collided with a pole. Do you intend to use that outside of...
Wait, did you want to say something? Were you talking?
It's just funny. He's saying it's not balanced on top of the flagpole. I'm glad he clarified that.
of cross-examination of Mr. Poole if he testifies?
No, that was the only that I used it in the
Okay.
It became relevant based on an answer or answers that Mr. Poole gave during cross-examination.
Okay.
So,
That to me seems the only way it would be relevant, unless Mr. Miller says some things in his opening. So I'm going to reserve ruling on that, Mr. Miller. It depends on whether Mr. Poole testifies and how that testimony goes. But if Mr. Poole is talking about a spotless driving record, then that photo is sufficiently relevant that it will come in. I don't remember the specific context when it came in, but it strikes me as appropriate impeachment material on cross-examination, but not affirmatively through other witnesses. Hey, do you remember when this happened to Mr. Poole? That wouldn't be appropriate. So we'll see if that situation arises again and assess it then. Okay. Mr. Body, any in limine motions from the state?
one just recently learned during the prior trial, Joseph Connors, who was the EMT, testified. The investigator working on this was able to recently confirm that he recently has passed away.
Sorry to hear that.
So state under 804, you want to show that he's obviously unavailable due to his death. Under 804A would be moving the court to allow the reading of his prior testimony into the trial, due to the fact that obviously both sides have the opportunity to question him as required by the law.
Okay. This is new to me and to you, Mr. Miller, so I'm going to think about it a little bit. But that does seem to be one of those scenarios when prior testimony can come in when the witness is deceased, but was subject to cross-examination here, not just by anyone, but by you in particular. Your thoughts about that?
Yeah, we actually found out about this back in April. So it's not new information. We passed it in January.
Well, it's new to me.
Yeah, but to that point, the only testimony that Mr. Connors, the only reason that Mr. Connors was called was to impeach him, because if y'all remember, he's the only witness that had no firsthand knowledge of this accident, did not recollect, did not recall anything. And so I think it's improper to impeach a sheet of paper.
Well, I guess what I need to do is look at his testimony. So we're going to take a break in a minute. Sounds like folks are here.
Paperwork.
Oh, I got some paperwork here. So maybe it's not for you. Maybe I think she's doing that now. Yeah. I don't think she would have given me the only ones. So I'm guessing she's making copies.
So we're going to jump to the next stream because he's just going to do his closing parts here. Also, shout out to Tanya Garrett. Super duper super chat over here. Shout out.
Yeah.
All the support for Jim is awesome. I like the simulcasting now that we figured out how to get it going on your stream.
If by we mean you telling me how to do it, then yes, we figured it out.
Well, because I think most of the other time I'll start and then like you'll join like partway.
Yeah.
Usually when I'm reading a motion or something, like you'll
Sure,
join
sure.
partway through. But it's been really cool to just start this all in one with, again, the hybrid gang chat going on. We've got, again, thanks to Factual Lie for queuing up. Let me get to this timestamp for the next feed.
Let me just step away for 1 second.
Yeah.
All right.
Everybody talk junk while he's gone. Throw tomatoes at Jim. All right, so this is going to be... Okay, yeah, so this was yesterday. Oh, so he didn't make a decision on this until... Well, that makes sense, because I think I tuned in yesterday, and that would explain why I couldn't find it in Tuesday's stream. So... Factual Lie saved us from just getting lost trying to hear something. Before we play this then, there was a moment from the first day of trial, so 2 days ago, about a sequestration issue. And I'll wait till Jim gets back, but I think we should just hear the fun, all good Fulton County times. Let me step away for a second and then immediately trips. SD says, I gotta look this case up because I have no idea about this trial. I was watching the Courtney thing and missed all of this. So we came into this blind. We just knew that the state, Fulton County District Attorney's Office, was going to argue they want to bring Juror 29 from the first trial in for a retrial as an expert witness and weighing all these issues. So that's kind of all I knew about it. Factual Lie sent it to me. I sent it to Jim, and Jim was like, what? So here we are. That's how we got here. But we pretty much picked up on, the defense is going to argue that the state can't even prove beyond a reasonable doubt that their client was the one driving the car during this fatal accident. That the vehicle that they were in, whoever was driving it, was the cause of the accident. They were going to say that their client, Poole, was the passenger. State is going to argue the opposite. So,
yeah. Also, shut up, Aaron.
For this one. But did you come back with the dog?
I did.
Yeah. So there we go. It was all worth it.
Aaron can't look, but everyone else can see.
Aw, dogs in the chat. And again, so you stepped away, but instead of jumping, McBurney makes his decision on day 2.
Okay.
Before we get there, we're going to look at this sequestration thing from day 1.
Yeah.
Because, of course.
Abate for that.
Oh.
Okay, is this your witness or do we need Mr. Abate for that? Great, okay. Mr. Miller, anything we need to discuss?
Yes, Your Honor. I would just ask if the court could caution everyone here that once a witness is sworn in, investigator, attorney, no one should be having a conversation with that witness while they're actively on the stand.
Okay.
That happens while we were in the back having questionnaires. And then we saw a different demeanor from the mother when we returned from that questionnaire. But it is very improper for a witness that's been sworn in to have members of the prosecution talking to her.
Too damn late.
So I agree with you if it's substantive. I was out in the hallway with you, so I don't know what happened, but if it is, are you doing okay? Can I bring you water? That kind of thing. I'm not going to prohibit that from happening, but you're exactly right. If it's anything about testimony, what you need to say, how to handle things, that would be very inappropriate and should be brought to my attention. I did notice the change of demeanor as well, but this was a very difficult topic, and there are lots of things that were at play during both direct and cross-examination. But it's a point well taken, and you flagged a related concern before we started the trial, and it's important
a familiar
that,
concern.
The members of the viewing audience maintain decorum and not interact in problematic ways outside the courtroom either. So I appreciate you sharing that. Anything else?
And then I had caught just from the chat that people were noticing that the mom, that's the witness that they're speaking of here, was switching up. But I have not watched the trial. I just noticed the chat in Judge McBurney's chat, reacting, saying as much. And then we're going to get to the snippet where we get some rulings.
Okay, here we go.
Oh, wait, I think I need to boost it. Okay, it's boosted.
You need to think about his testimony solely as the medical professional who says the injuries.
Oh, let me start with the beginning of the, I think it jumped forward. Yeah, let's go back a little bit more.
Let's try to read the caption really fast to see what he says.
Oh yeah, and he talks about California's version of 403, so which I always forget. What is 3 something, right?
Oh
He
God,
says
please
it.
don't ask me.
You guys are the only ones that don't want to just adopt the federal rule of 403 and have to have your own number.
I don't even know California law. I know Georgia law. I don't even license. I've been to Georgia twice, and I can't even practice there. I don't know how I passed the bar.
Okay. So we'll put this, is this sped up in case I'm going too far back?
They're ready to go? Okay. They're what?
They're introducing themselves to each other.
Like they never met before? Okay. Hey, I'm a juror. Nice to meet you.
What? I'm lost.
If you just step out, if there's something that needs to be addressed, I can probably handle the person, right?
All right. Well, let's get on the record. We are together on Wednesday, the 3rd of December for day 2 of the evidentiary portion of the trial of State versus Poole. Mr. Poole is here with his lawyers. Mr. Rao is here for the state. And I want to talk about Dr. Is it Rogi or Rogi? I don't want to get it wrong.
I know it's Brogy.
Brogy. Okay, Dr. Brogy. Yes, Brogy. So I have thought through this. I did find a case out of California. It was the retrial of a death penalty case in which during the sentencing phase of the second trial, the defense wanted to call 2 jurors from the first trial who, since the first trial, had befriended the defendant, spent time with him in jail, not as in other inmates, but went and counseled this defendant, and they wanted to talk to the jury about how this person had rehabilitated himself. And the trial
totally
judge
different.
excluded it on 403 grounds. In California, it's called Rule 352. It was basically 403. Went up to the Supreme Court, death penalty case, and the Supreme Court affirmed the trial judge's application of 403 to that situation, and went on to note that even though the defense attorneys, not during the trial but on appeal, argued that there's a possible limiting instruction along the lines of telling jurors to give no greater weight to the testimony of the witness just because that person had been a juror before, the Supreme Court wasn't sure that that would have been enough, but didn't need to reach that because the judge made the decision that the judge did. I find that there are a couple reasons why it would not be appropriate for Dr. Brogy to testify. One is 403. My concern primarily is that in the end, and the other is 606B, but in the end, for the defense to thoroughly explore Dr. Brogy's motive for testifying, his potential biases, et cetera, they would need to explore the fact that he had been a juror before. And that, I think, is a 403 issue in that the undue prejudice substantially outweighs the probative value because Dr. Brogy is not a witness who the day after trial happened to see, and I'm making this up, Mr. Poole driving, celebrating, and going 100 miles up the off-ramp where he uniquely saw a set of facts that no one else saw. Dr. Brogy is only uniquely positioned in that he was a juror. He's not the only orthopedic surgeon in Atlanta, in Metro Atlanta, in Georgia. And so I don't find that he's the only person who could be brought to bear to talk about the kinds of things that are set forth in his conclusions. But because he was a juror and Mr. Miller or Ms. Bird would be entitled to explore with Dr. Brogy his views during deliberations. And
whose face?
Miller's mainly.
He looks like he's busy writing. What note is he even writing right now over here?
I have so many jokes I can say, but none of them are appropriate.
We're going to hit the play button.
606B prohibits that, but I think that the defendant's right to confront this witness would overcome that prohibition, which then gets into the whole policy space of jurors should never be forced to talk about what went on in deliberations. And one could argue Dr. Broggie is waiving that by coming in to testify, but in some ways it's not his.
He's swiping his nose quite a bit here. I thought that was something you're not supposed to do.
Gets into the whole policy space of jurors should never be forced to talk about what went on in deliberations. And one could argue Dr. Broggie is waiving that by coming in to testify. But in some ways, it's not his to waive, especially if what the defense wanted to explore was, well, what were other jurors saying? And were they pushing back on what you had to say? And did you become something of a missionary in this space? And he'd reject that characterization, but you'd be free to characterize it that way and argue that to the jury. And then Dr. Broggie would necessarily be talking about what other jurors said. And they had no.
Somebody's getting really red right now.
Waive their 606B rights, or the state hasn't waived them for them if they're waivable. There's really not case law on whose rights they are. The case law is about the policy behind 606B, which is that jurors should be free to talk about things the way they want to talk about them and never have to worry that they'll be asked to explain how things went down in the jury room and why and what they might have said about the judge or a prosecutor or the defendant. And we necessarily.
That's new. We didn't hear that discussed during the arguments.
Yeah.
But like protecting the sanctity of this jury for round 2, not having to worry that whatever they deliberate will be like,
that's smart.
You don't want to suppress their deliberations. Yeah,
that's really interesting. I hadn't thought about that. That's a good argument.
Yeah.
Yeah. I mean, he's really just saying like, this is y'all messy.
for a few reasons.
Yeah. It's like, what are you doing?
But that's what I was trying to explain, chat. Like McBurney, it's almost like he treats the courtroom and arguments like a professor would treat a class and give them like, how would you argue this? What would you say? And just lets everything float out into the air. And then he'll come back and be like, well, here's a decision. So always interesting, I think, to watch a McBurney proceeding.
I believe, get into that space. And finally, and this is the other 403, so the one 403 concern is that we create a side circus. And mostly when people talk about 403, it's the undue prejudice that substantially outweighs the probative value. But there's also, if it's confusing or a distraction to the jury, I'm not saying we are retrying the case here, but Mr. Miller and Ms. Bird would be entitled to burrow pretty deeply into the deliberations. And that becomes, I believe, an unnecessary sideshow. But the bigger 403 factor is that I am concerned that lay jurors on this jury would say, here's a guy who heard all the evidence we did. He is a medical professional, and he is saying, in essence, my words, not his, Poole had to be in the driver's seat. Gosh, I don't really need to deliberate now because he heard everything I heard, and he's super smart in the space that matters of the nature of the injuries, et cetera. And so this is really what decides the case for me. This is clearly probative, and I need to weigh that. And it has to be substantially outweighed by that undue prejudice and or risk of confusion. I am, in my calculus, lessening the probative value in this sense. Dr. Broggie isn't the only person who could do this. There are other doctors I am convinced that the state could have found once Dr. Broggie said, let me tell you, having looked at the medical records or heard the evidence, Poole's injuries are totally consistent with having been the driver and maybe the guy found in the backseat. They're not consistent, whatever his conclusions were. Hopefully, they're not so far out to left field that there'd be other doctors who could say it. And it's because there are replacements out there at Grady, at Piedmont, at Northside, pick your local hospital, who don't have that additional layer of complexity, prejudice, et cetera, that I find that Dr. Broggie's the probative value of his testimony is lessened because it's not unique. Again, I go back to my original. If he was the only person who had seen Mr. Poole speeding away after the trial was over, going up, running from the police, going up exit 2 on 400, he's the only guy who could talk about that. And so the probative value would be profound. There's no substitute, but there are substitutes for Dr. Broggie. And so I think that we improperly, through 403, introduce undue prejudice, to the extent that it substantially outweighs the probative value. And it's a two-barreled answer here. It also would create sufficient confusion for the jury by getting into, wait, this previous trial, and he was on the side to convict. And I think either side would be able to ask him, and What were the numbers? Was it 10-2 to convict? Oh my gosh, most people were going to convict. Again, nothing that this jury ought to know about or ought to be thinking about. And I don't believe any limiting instruction I could give. It's sort of like when I was telling them with a mistrial. If I tell them you need to disregard what you just heard, and it was someone saying, Mr. Poole told me he was the driver, and for whatever reason that was inadmissible, they're not going to forget that someone said that. And we'd have a mistrial because you can't unring that bell. And I don't think a limiting instruction from me saying, but don't worry about that Dr. Broggie said it was 10-2 to convict. Don't worry about the fact that he was a juror. You need to think about his testimony solely as the medical professional who says the injuries that Mr. Poole sustained were consistent with him being the driver of the car. That's my ruling. Mr. Abate or Mr. Rao, do you want to get anything on the record to preserve it in case this is something that gets challenged on appeal? Okay. Mr. Miller, anything you want to add? Okay. Mr. Abate, Mr. Rao said.
Sorry, go ahead.
Oh, man.
I think that was it. That wraps up that whole issue. So,
Yeah, it's just pretty simple ruling, I think.
Yeah, of course they don't have anything to say.
That was thorough. That was a thorough examination. All of the many reasons why it shouldn't be allowed.
That was very McBurney. Very McBurney. And as Aaron says McBurney's analysis is why I don't get annoyed that he asks so many hypothetical questions. He always provides a very thorough, well-founded ruling. Although I do have to say, I think McBurney is at the right bench at this level and what he does. Imagine him trying to, if he was on the panel, like the Georgia Supreme Court, the way he would run up somebody's 5-minute argument window asking all the questions.
Yeah.
The record would be 5 minutes of McBurney.
Oh, man. Yeah. I love the Georgia Supreme Court. I love Pinson. I've been a big Pinson fan lately. You just ask a question and it's like, why isn't this the right answer? And then they can never answer why it's not the right answer, and then that's the end of the argument.
On the 9th, so on Tuesday, is that starting at like 10 a.m. Eastern?
Which one?
Or are you just going to watch it whenever and not watch it live?
Oh, yeah, I'm not sure. I'm going to watch it live. I'm not sure when in the hearing it is, so I don't know exactly what time.
I'm sorry, what was the summary? So I know that it's going to be Brian Steele arguing, but what's like the issue for the Supreme Court to consider?
Yeah, the first one is sufficiency of evidence, which is just what you always do. The second one is, I haven't looked at it in detail yet. I know one of them is there was a juror who wanted to get off the panel because they were a victim in a case that was being heard elsewhere in the courtroom at the same time as this case was being heard. And then I think there might have been a corroboration issue. But yeah, I think it was just the three.
An cumulative error.
Yeah, I'm sure. Ryan loves his cumulative errors.
Yeah. There's always an extra when he does his arguments. So Jim's going to be doing that on Tuesday. That's always good. I love listening. I just like the auditory, like the acoustic sound of those oral arguments.
You know what I love about Brian in his briefs? He always says, petitioner rots in the Georgia State Prison. Or petitioner has been rotting in the Georgia State Prison for 3 years.
Well, you got to make it visual. Like you got to you got to make it seem
no pun intended.
No. So there's that, you guys. Tomorrow we'll be doing here, and you're welcome to pop in. I don't know if Courtney Clenny's hearing is going to be streamed. If it is, we'll start earlier in the morning. That's a Florida case, so East Coast time. They usually start around 9 a.m. If there's a stream, we'll go live for that. If there's no camera feed for that hearing, I won't be going live. We'll just do an update and post with it. But then Cardi B's hearing. Cardi B, Amani Ellis, sanctions for attorney Ron, the motion for a new trial. That's all going to be streamed. I saw Law and Crime put in a request, and the judge has granted their media request. So we will be watching that. I got to get the start time right, but probably like 11:30 Eastern. So I'll start whenever they start, and you're welcome if you want to come hang out.
Are we covering this trial?
I don't know. I mean, I think 3 days first trial.
Yeah,
I would imagine, and they're on day 3 for the retrial today, right? Let's go to McBurney's channel.
Yeah, I saw that he was on lunch break earlier because he had a picture of a peanut butter and jelly sandwich as the screensaver. And I think it was like pho, a burger, a PB&J sandwich, and one other thing. And I was just wondering like which one was his favorite.
Oh goodness. Why is he calling this round 2? Did they have it? Hold on, look. Today's stream round 2, day 3. Let's see.
So they're
No, it looks like they've been going the whole time.
Oh
So
yeah.
I wonder why he's calling
Oh, there,
it.
there's the lunch.
There it is.
There we go. A salad. That's what I forgot. A salad.
Of course, we forget the salad. My goodness. So I don't know. I think it could be manageable because it's presumably going to end soon, unless they're suddenly calling 1 million more witnesses that they didn't call the first trial.
Well, listen, I think they're down 1 witness, so
well, maybe 2. Maybe 2.
true.
So, guys, I think the premise of the case is a fatal car accident. 2 individuals died. Like, that sucks. That's really sad. But they're accusing one guy of causing the accident, and the defense is like, my client wasn't the driver. So, what are we doing? What are we doing? So, yeah, I don't know. I'd be open to figuring out. Of course, I'd prefer, skipping breaks, watching on a faster speed, since it's a retrial anyway, since it's old footage. But yeah, if you want to figure something out.
Yeah, we can talk after.
Yeah. All right, guys. So we're going to wrap this up. Thank you to everyone for hanging out. I see SW here sneaking one gift over on your side there, Jim.
Yeah, thank you, everybody. I think I missed one.
It is like, here, let's go through them again. So thank you, everyone. It's a little bit weird back here. So shout out to SW, shout out to Tanya, shout out to O'Bailey's, aka Factual Lie. And, I feel weird when I'm like, Factual Lie said, Factual Lie is a reliable source. Don't be confused by the oxymoronic name. Gwennon, we've got Love Amy E in the building. Thank you. We got Gwennon again. We got Sheriff Chuck 2 times. So if you want to go and check out the theme song after this, let him be your inspiration. We've got B-Mac, aka Nana Banana, and James Phipps. So thank you guys. And sorry it's awkward. The simulcasting, it's a bit awkward to figure out back here what's coming from where. Can you put things on the screen? If you click chats or no?
Wait, what's that?
If you click like a chat, can you put anything on the screen? Or is it only me?
I think it's just you. Hold on, let me see. I think I tried earlier. I can delete, put user in timeout, or ban user, but I can't I can only do negative things. I can't do positive things. I can only punish. I can't reward.
All right, yeah, let's not play with that back here then. So,
like
yeah.
For example, let me show. I'm gonna ban Aaron, for example.
No.
For unkind
no,
jokes.
I'm gonna end the stream. I'm ending the stream.